Okay, so good evening everyone and welcome on behalf of BACFI and the Inner Temple Employed Bar Forum. Sarah Lawson was hoping to be here this evening but she can't make it, so I'm extending my thanks to Inner Temple on her behalf. Tonight's Denning lecture is the topic of contracts, certainty and the Supreme Court. For those that don't know me, I'm Gaynor. I'm the current chair of BACFI. I also wanted to take this opportunity, but I don't see her here, but to introduce Sarah George, who's been elected to take over as BACFI chair from January. For my own part, I just wanted to say thank you to everyone in the audience and everyone that's helped out over the years and really supported me as the chair. It's been an absolute pleasure. Tonight we're very honoured to be joined by Professor Ewan McKendrick, KC. Professor McKendrick is a Professor of Anglo-American Law at the University of Leiden and a barrister at 3 Verulam Buildings in Grays. He's an Emeritus Professor of English Private Law at the University of Oxford and an Emeritus Fellow of Lady Margaret Hall in Oxford. He's the editor of the Law Quarterly Review and editor of Chitty on Contracts. Gosh, everyone remembers that book from uni. He's the author of a number of books on contract law and commercial law. His inaugural lecture at the University of Leiden was on the subject of the importance of certainty in commercial contract law. And his lecture this evening is in many ways a continuation of that lecture. Before I pass over to Professor McKendrick, I just wanted to extend my thanks also to Mark Wealth Management, who have been great supporters of BACFI over the years and who are sponsoring the event again this evening. So thank you to that. So I'm going to hand over. Thank you.
Thank you very much, Gaynor, and thank you for finding the time to come this evening and for the invitation to give this lecture. As Lord Hamblin observed in a recent Supreme Court decision, certainty and predictability are of particular importance in the context of English commercial law, all the more so given the frequent choice of English law as the governing law in international commercial transactions. This is not a new refrain on the part of justices of the Supreme Court, although it would also be true, I think, to say that it's a view that hasn't been universally shared by all of the justices all of the time. One possible reason for this apparent difference of view is that, as Lord Mance once observed, certainty is not the ultimate or wholly achievable aim of the law. Thus, the commitment to the attainment of certainty and predictability, while important, is not absolute, and is generally expressed by the Supreme Court in qualified terms. For example, the aim is to avoid unwanted or unnecessary uncertainty, or to foster certainty so far as the court can do so. The pursuit of certainty and predictability is therefore a very important feature or desideratum of the English law of contract, but it's not a legal principle or a legal rule, nor is it the only aim of the law of contract. It is therefore no surprise to find that the importance attached to certainty appears to vary depending on the identity of the parties to the contract and the nature of the contract into which they have entered. The importance attached to certainty appears to be at its highest when the contract is in written form and has been entered into by commercial parties of roughly equal bargaining power who have the means of access to professional legal advice. Conversely, where the parties are of grossly unequal bargaining power, or the relationship between them is characterized by a high degree of informality, the emphasis placed on the importance of certainty may not be as great. This being the case, it is perhaps no surprise to discover that while it's true to say that examples can be found of clear affirmations by the Supreme Court of the importance of certainty and predictability in English contract law, a closer study of recent case law demonstrates that the emphasis placed by the Supreme Court on the importance of certainty does vary depending on the context in which the contract was concluded, the identity of the parties to the contract, and the quality of the behaviour of the parties to the contract. Before proceeding to examine in more detail 3 recent Supreme Court decisions, I could provide a short working definition of certainty. What I mean by certainty is legal certainty. That is to say, the clarity of the substantive content of the rules of English contract law. Do they provide clear guidance to contracting parties when drafting a contract, when deciding whether or not to exercise a right that is believed to be contained within the contract, and in the event that disputes arise between contracting parties, as to the likely outcome of any judicial resolution of that conflict. In the words of Lord Bingham, the vital issue is whether the rules of law are accessible and, as far as possible, intelligible, clear and predictable, in order to ensure that questions of legal right and liability should ordinarily be resolved by application of the law and not the exercise of discretion. As I've indicated, my particular focus this evening is on the role that certainty and predictability have played in 3 recent Supreme Court decisions in the field of English contract law. These cases being RTI and MUR Shipping, Waller Edwards and One Saving Bank, and going back slightly further in time, Times Travel and Pakistan International Airlines. So, without further ado, let me start with my first case, RTI and MUR Shipping. The issue before the court here was one that concerned the proper interpretation of a contract of affreightment based on an amended GENCON form of voyage charter party. The charterer of the vessel was a company based in Jersey, and it was obliged under the terms of the contract to make payment to the shipowner, a Dutch company, in US dollars. However, as a result of sanctions being imposed on the corporate group of which the charterer was a member, it was common ground between the parties that it had become highly probable that there would be difficulties in making timely payment of hire in US dollars and that any such payments would have been delayed. In this situation, one might have expected it to be the charterer who wished to rely on the force majeure clause as a defence to any claim brought against it in respect of a failure to make timely payment. After all, it was the party facing the difficulty of making payment in accordance with the terms of the contract. But this was not in fact what occurred. It was the shipowner, as the recipient of the payment, who was seeking to rely on the force majeure clause in order to justify its decision to suspend performance of the contract and its refusal to nominate vessels under the contract. Rather than seek to walk away from the contract or to suspend its performance, the charterer sought to find a way to ensure that the shipowner did receive the payment to which it was entitled under the contract. And to that end, it offered to make payment to the shipowner initially in euros and then to pay the cost of immediately converting the euros into US dollars. And in this way, the shipowner would receive payment in US dollars of the correct amount, but it would do so via a 2-step process rather than the single stage agreed in the contract. The shipowner, however, declined to accept payment in this form, maintaining that the agreed method of payment was in US dollars, not euros, and that the force majeure clause did not oblige it to accept payment in any other form. In essence, the shipowner's position was that the imposition of sanctions was an event that was beyond the control of the parties, that had the effect of preventing payment being made in US dollars as required by the contract, and thus amounted to a force majeure event. The charter, by contrast, denied that the force majeure clause had the effect for which the shipowner contended. It pointed to the fact that one of the elements of the force majeure clause was that the event must be one which, quote, cannot be overcome by reasonable endeavours from the party affected. In its submission, reasonable endeavours required the shipowner to accept the offer to make payment in euros, which would then be credited to the shipowner in US dollars as soon as the euros were received. Notwithstanding the simplicity of the fact pattern, the legal issue that it generated proved to be far from simple to resolve. The case started life in arbitral proceedings, from which there was an appeal to the courts. The arbitrators and the majority of the Court of Appeal found for the charter and held that the shipowner was not entitled to rely on the force majeure clause because of the effect of the reasonable endeavours provision. However, Mr. Justice Jacobs in the Commercial Court, the dissenting judge in the Court of Appeal, and a unanimous Supreme Court found for the ship owner and held that it was entitled to rely on the force majeure clause and was not obliged to accept payment in the manner proposed by the Charter. In giving the judgment of the Supreme Court, Lord Hamblin and Lord Burrows, in a joint judgment, identified several principles which together in their judgment provided good reasons for accepting the submissions advanced on behalf of the shipowner. The first was that the object of a reasonable endeavour's obligation is to maintain contractual performance, and it's not concerned with the steps that could or should have been taken to secure some different non-contractual performance. The second was the principle of freedom of contract, which is fundamental to the English law of contract, and this principle was held to include the freedom not to contract, and that freedom was extended to a freedom not to accept the offer of a non-contractual performance. The third is that clear words are needed to forego valuable rights, and the right of the shipowner to be paid in US dollars was found to be such a valuable right. The fourth, and the reason of greatest interest for present purposes, is the importance of certainty in commercial contracts. Thus, the argument advanced on behalf of the shipowner was said to be straightforward, while the submissions advanced on behalf of the Charter were said not to be anchored in the contract and were said to beg a number of questions and to give rise to considerable legal and factual uncertainty. And this uncertainty was said to be particularly detrimental in the context of a clause which requires immediate judgments to be made and where contracting parties need to know with reasonable confidence whether or not the force majeure clause can be relied upon at the relevant time, not after some retrospective inquiry. Now, it seems to me it's important not to overstate the significance of the importance attached by the Supreme Court to commercial certainty in reaching its decision. It was but one of four principles identified by Lord Hamblin and Lord Burrows, and it can't be said with confidence that it played a decisive role in the decision-making process. On the other hand, it is the principle that received the most detailed treatment in the judgment of the Supreme Court, and on that basis, it would seem reasonable to assume that it was a material factor in persuading the Supreme Court to reach the decision which it did. To the extent it was a material factor, it can be argued that too much weight was attached to its significance, and this is so for a number of reasons. First, and this is a lesser point, the Supreme Court's focus on the importance of certainty was essentially confined to its consideration of the term that required payment to be made in US dollars. Yet the significance of that term could perhaps have benefited from greater consideration. It would appear that the case before the Supreme Court proceeded on the assumption that as between the parties, US dollars were both the money of account and the money of payment, and that the law applicable to both was the law applicable to the contract and not the law of the place of performance. However, this assumption was perhaps open to question, at least at an earlier stage in the proceedings, i.e. in the arbitral proceedings, if not in the Supreme Court, because the place of payment was the Netherlands, and Dutch law generally allows payment to be made in euros rather than in any agreed upon foreign currency. Thus, had Dutch law governed the money of payment, then the Charter would have been entitled to make payment in euros, and there would have been no question of any non-performance by the Charter. In many ways, it's unfortunate the point was not pursued in any more detail, but when seeking to analyse the decision of the court, one has to proceed on the basis that there was no entitlement on the part of the Charter to make payment in euros, and that the tender of payment in euros amounted to a non-contractual performance. Secondly, and more significantly, the almost exclusive focus on the obligation to make payment in US dollars had the consequence that little or no attention was paid to the entirety of the contractual relationship between the parties and their aim in securing performance of the contract. Had a broader approach been taken, regard could have been had to the fact that it was the shipowner who was seeking to suspend performance of the contract and who declined to cooperate with the Charter in such a way as to ensure that the intended end result of the contract was achieved. Lord Hamblin and Lord Burrows, however, approached the case on the basis that it was the shipowner who was insisting on contractual performance, rather than viewing the shipowner as the party who wanted to walk away from the transaction and frustrate the achievement of the ultimate purpose of the contract. Third, and relatedly, the Supreme Court did not attach any weight to the fact that the position of the shipowner could be said to be not entirely meritorious, given that the option offered by the charterer would have resulted in it obtaining immediate payment in US dollars. Indeed, Lord Justice Arnold, in his dissenting judgment in the Court of Appeal, observed that the position of the shipowner had, quote, no merit. But this statement was deemed to be misplaced by Lord Hamblin and Lord Burrows because, in their view, it was not unmeritorious or unjust to insist on contractual performance, all the more so if being precluded from doing so would introduce uncertainty, contrary to the expectations of reasonable business people. However, it can be argued that the reasonable business person might have expected the contract to be performed by acceptance of the charterer's proposal, given that performance could then be achieved at minimal expense or inconvenience to the shipowner, and the contractual relationship between the parties maintained. Fourth, the concern of Lord Hamblin and Lord Burrows in relation to the dangers of opening the door and accepting that there may be circumstances in which a contracting party may be obliged to accept what would otherwise be a non-contractual performance may be said to be somewhat overstated. This concern can be seen most clearly in the consideration given to the question of the identification of a detriment or other prejudice which a party may be required to accept, or the extent to which it can be said that the non-contractual performance can be said to achieve the same result as performance of the contractual obligation in question. These are clearly legitimate concerns because once the door is opened, it's difficult, if not impossible, to close it again. But on the present facts, it can be said that the strength of the charterer's case was that the shipowner would obtain the performance for which it contracted as a result of the immediate conversion of the payment in euros into US dollars. This was not a case in which what was being offered would result in a different outcome or an altered end result. It was the mechanism to achieve the result that was altered, not the result itself. Fifth, it is important, I think, to recognise that the clause in dispute was a force majeure clause, and the context in which such a clause is intended to operate is one in which performance has been interrupted by an event that's beyond the control of the parties, such that performance cannot be carried out according to the original contractual schedule. For example, an interruption in performance caused by adverse weather, a strike, or the outbreak of war may lead to the temporary suspension of the contract and delivery at a time other than that set out in the contract. In such a case, one would not expect the recipient of the contractual performance to decline it on the basis that it was being tendered at a time other than that set out in the original contractual schedule. However, the present case may be said to be atypical in that it was the recipient of the contractual performance, not the party subject to the obligation to perform, who was seeking to rely on the force majeure clause. But what if we change the facts? What would have been the position if it had been the charterer who sought to rely on the force majeure clause, and the shipowner was the one who came forward with the proposal that the charterer pay in euros and meet the cost of conversion of that payment into US dollars? In such a case, could the charterer have relied on the force majeure clause as a defence to its non-performance and then maintained that it couldn't be required to tender performance in a form other than that set out in the contract? If this is so, then it may be that further thought needs to be given to the drafting of force majeure clauses, at least in the case where the aim of the clause is not simply to shield a party from liability for its non-performance, but to enable performance to be completed in a manner that is close as possible to the terms of the original contract. This leads on to the final point, which is that the maintenance of the contractual relationship under altered terms may have been the aim of the reasonable endeavours provision in the force majeure clause, which could be said to evidence not only a desire to achieve performance as close as possible to that set out in the original contract, but to demonstrate that the parties did place a value on flexibility, notwithstanding the uncertainty that such flexibility may entail. The existence of a degree of uncertainty in the clause was indeed acknowledged by Lord Hamblin and Lord Burrows, insofar as they recognised that a reasonable endeavours obligation imports an evaluative judgment and therefore some element of uncertainty. However, their response was that such an evaluation was geared towards achieving contractual performance, and that the construction favoured by the Charter created needless additional uncertainty insofar as it departed from the standard terms of the contract. And while, of course, it's true that the proposal made by the Charter did involve a departure from the standard provided by the terms of the contract, the impositions of sanctions already had that inevitable consequence. And the merit of the proposal made by the Charters was that it was designed to achieve an outcome that was as close as possible in the changed circumstances to that standard. Notwithstanding these criticisms of the decision of the Supreme Court, there is of value in this decision, particularly its confirmation of the fact that a force majeure clause will generally be interpreted as being applicable only if the parties invoking it can show that the event or state of affairs was beyond its reasonable control, and that the event or state of affairs must be such as could not be avoided by the taking of reasonable steps. The essence of my criticism is that the decision gives too much weight to the need for certainty and exact contractual performance in a context where performance is no longer possible in accordance with the original contractual timetable, and it doesn't encourage parties to seek to obtain a contractual performance that is close as possible to that which was originally agreed. Turning now to my second case, which is the decision of the Supreme Court in Waller-Edwards and One Saving Bank. Now, you could say that this is not the most appropriate case for me to consider in this context because it's not a purely commercial transaction. It's a transaction between a consumer and a bank, and it has no international component because both parties were resident in England. Nevertheless, I think the case is of interest insofar as it illustrates the concern of the Supreme Court to find a clear rule which can assist the commercial party in its business and thereby promote certainty in transactions. The issue before the Supreme Court in this case was one that concerned the circumstances in which a bank is putting on inquiry in relation to the risk that undue influence has been exerted over a non-commercial party to whom money has been advanced by way of a loan from the bank. Now, the particular issue in this case arose from the fact that the loan took what was called a hybrid form. So the majority of it, advanced by the bank, some $384,000, was on the face of it for the benefit of both parties, so it was in that sense a joint loan for a joint purpose. But there was also an element of it which was solely for the benefit of the defendant's partner, insofar it was being used to pay off £39,500 of his debts. So the case was neither the classic surety case, where the bank would be put on notice, nor was it a case where the advance was entirely for the joint non-commercial purposes of both borrowers, in which case the bank would not ordinarily have been put on notice. Here, the Supreme Court, in a judgment delivered by Lady Simler, rejected a fact-sensitive approach to the question of whether the bank was put on notice, preferring a binary approach according to which either there is, on the face of the non-commercial transaction, a surety element giving rise to a heightened risk of undue influence, or there is not. If there is such a surety element, the bank is put on notice. The test adopted by the Supreme Court was in the following terms. A creditor is put on inquiry in any non-commercial hybrid transaction where, on the face of the transaction, there is a more than de minimis element of borrowing which serves to discharge the debts of one of the borrowers and so might not be to the financial advantage of the other. Although the de minimis exception may introduce a degree of uncertainty into what was repeatedly said to be a bright-line test, the de minimis exception was believed to be of such long standing that it would not be a source of unworkable certainty, and in any event on the facts, a surety component of £39,500 could not be regarded as de minimis. The advantage of a bright line approach over a more fact-sensitive approach was said to be that it was, quote, clear, promotes certainty, and most significantly, it is easy to apply effectively in all non-commercial hybrid transactions. In adopting this bright line approach, the Supreme Court viewed the transaction through the lens of the bank, noting that it was the bank's perception of the nature of the transaction that was critical. Viewed from this perspective, the primary interest of the bank was seen to lie in establishing a clear and a workable rule, which had as its focus what was on the face of the transaction, even if that rule resulted in the bank being put on notice in a wider range of circumstances than might have been the case had a more nuanced, fact-sensitive approach been adopted. In approaching the case in this way, one can see the importance which the Supreme Court attached to the importance of the provision of certainty and predictability to commercial parties. However, it is important to note that the focus on certainty was largely, if not exclusively, confined to the position of the bank. Matters were otherwise in relation to the position of the defendant borrower. While she did have an interest in the adoption of a clear rule, in the sense that all of us as citizens have an interest in knowing their rights with a degree of certainty, she was looking primarily to the court for protection, not certainty. And this interest was acknowledged by Lady Simler when she observed that the Supreme Court's approach would, in addition to providing certainty, quote, afford a broad scope of protection by putting a bank on inquiry in every non-commercial case where a wife offers to stand surety for a loan used to pay off her husband's debts to a more than de minimis extent. And in so concluding, Lady Simler acknowledged that the prevalence of economic abuse between women and their spouses or intimate partners has not reduced, and that as many as 1 in 6 women in the UK has experienced financial abuse by a current or former intimate partner. The Supreme Court, therefore, did not make the mistake of assuming that certainty was the only interest that was worthy of protection. There was a concern to protect the vulnerable from abuse, even though it may be doubted whether a dispassionate explanation of the proposed transaction under the Ettridge Protocol will suffice to free a vulnerable person from the undue influence of a partner. But the adequacy of the Ettridge Protocol is not my immediate concern tonight. It suffices to note that a concern to promote certainty and predictability need not be at the expense of a desire to protect the vulnerable from exploitation. Rather, the task of the court is to strike a balance between these often competing interests, although I think it would be fair to say that the weight that is attached to the promotion of certainty and predictability in English law is probably greater than that to be found in many other legal systems of the world. My third and final case is the decision of the Supreme Court in Pakistan International Airlines and Times Travel. Here, the claimant travel agents sought to set aside an agreement into which it had entered with the defendant airline company on the ground of economic duress. The agreement was entered into between the parties after the defendant had given notice lawfully to terminate its existing contract with the claimant and then offered the claimant a new contract on terms that included a waiver by the claimant of any existing right which it had against the defendant in respect of unpaid commission under the contract which had been terminated. The defendant's case was that such conduct could not amount to the application of illegitimate pressure because the steps it had taken were entirely lawful. It had terminated an existing contract by the giving of notice in accordance with the terms of the contract and then offered a new contract on new terms as it was entitled to do. The issue before the Supreme Court was therefore whether or not English law recognised the doctrine of lawful act duress, which entitled the claimant to set aside the agreement. On this issue, the Supreme Court held unanimously that English law does recognise a doctrine of lawful act duress, but that the claimant was not entitled to invoke it on the facts of the case. In reaching this conclusion, the importance of certainty in commercial transactions weighed heavily with the Supreme Court. Thus Lord Burrows stated, and I quote, "Within the realm of commercial contracts with which we are here concerned, English law has a long-standing reputation for certainty and clarity, and there is a significant danger that that reputation will be lost if the law on lawful act economic duress is stated too widely or with insufficient precision." However, had the sole aim of the Supreme Court been to produce a clear and certain rule, the easiest way to achieve that would have been to conclude that English law does not recognise the doctrine of lawful act duress. Instead, the aim of the court was to avoid, quote, "unwanted uncertainty or unacceptable uncertainty." So why was the Supreme Court willing to accept a degree of uncertainty rather than shut the door completely on the recognition of lawful act duress? Lord Burrows gave 3 reasons in support of his conclusion that English law does recognise a doctrine of lawful act duress. The first is that the line drawn by the law when considering whether the pressure is of such a nature as potentially to amount to the application of economic duress is between illegitimate and legitimate pressure, not between unlawful and lawful pressure. The second is that the crime of blackmail clearly includes threats of lawful action, and it would be, in Lord Burrows' view, quote, "very odd for the civil law of duress not to include threats of lawful acts when the criminal law does so." Third, there is a long-established line of authority in which threats of lawful action have entitled the threatened party to rescind a contract or to have restitution of non-contractual payments, the classic examples being threats to prosecute the claimant or a member of the claimant's family, to which Lord Burrows added a number of more recent cases in which it has been accepted that lawful act economic duress can act as a ground for the avoidance of a contract or a ground for restitution. So against that background, the Supreme Court concludes that there is a doctrine of lawful act economic duress. The issue now becomes the scope of that doctrine, on which the Supreme Court divides, with Lord Hodge speaking for the majority, Lord Burrows in the minority. The intention of the Supreme Court in relation to the scope of the doctrine was clearly to recognise a doctrine of very limited application, and this has been followed in subsequent cases. There are presently 2 identified circumstances in which it can be invoked. The first is where a defendant uses his knowledge of criminal activity by the claimant or a member of the claimant's close family to obtain a personal benefit from the claimant by the express or implicit threat to report the crime or initiate a prosecution. Now, to the extent that such a threat involves the commission of the crime of blackmail, it shouldn't give rise to difficulty in practice, given that a commercial party might be expected to recognise that a contract entered into as a result of the threatened commission of a crime should be set aside by the court. More difficulty, however, is likely to arise from the other circumstance in which the majority of the Supreme Court recognised that lawful act duress may exist, namely where, and I quote, "a defendant having exposed himself to a civil claim by the claimant, for example for damages for breach of contract, deliberately moves the claimant into a position of vulnerability by means which the law regards as illegitimate and thereby forces the claimant to waive his claim." The element which Lord Hodge identified as common to these 2 circumstances is that the defendant has behaved in, quote, "a highly reprehensible way," which the courts have treated as amounting to illegitimate pressure. However, the scope of these exceptional circumstances, in particular the second one recognised by the majority, requires an evaluative assessment which inevitably brings with it a degree of uncertainty. And this point was noted by Lord Burrows, who observed that on the face of it, the conduct of the defendant on the facts of times travel seemed to fall within the second of Lord Hodge's 2 categories, insofar as the defendant used illegitimate means to manoeuvre the claimant into a position of weakness in order to force it to waive its claim in respect of the unpaid commission. Lord Hodge did not, however, share this view. In his judgment, Based on the findings made at trial, the conduct of the defendant entailed, quote, hard-nosed commercial negotiation that exploited the position of the defendant as a monopoly supplier, but it did not involve the reprehensible means of applying pressure that was evident in the case law in which economic duress has been found to exist. He also noted there was no finding that the defendant had acted in bad faith in making its demands. The line thus drawn by Lord Hodge between legitimate, hard-nosed commercial negotiation and reprehensible and therefore illegitimate means of applying pressure is not one that will strike all observers as being self-evident. At this point, it may be helpful to delve a little more fully into the facts of time's travel. While the finding that no reprehensible means were used by the defendant seems clear, if the giving of notice to terminate the original contract and the offer of new terms are viewed in isolation, the picture, I think, begins to change somewhat when account is taken of the context for these actions, namely the dispute under the original contract in relation to the payment of commission to the claimant. Unfortunately, the analysis of the true state of play in relation to the obligations of the parties under the original contract was not conclusively established by Mr. Justice Warren at trial. While he devoted over 200 paragraphs to an account of the facts, the section of his judgment in which the doctrine of economic duress was applied to these facts consists of 3 paragraphs. That said, there are some points on which there is some clarity in the findings made. So, for example, it's clear that the claims brought by the claimant were all genuine and arguable. But other points are less clear. Thus, the question whether the defendant had acted in good faith or bad faith was stated to be moot, because the claimant had not established that the defendant had acted in bad faith, while the defendant had not established that it acted in good faith. Further, there were elements of the claim to recover unpaid commission that were described as very strong indeed, and where a summary judgment application would have been bound to succeed, but there were other aspects of the claim where the outcome was found to be less clear, or the claim was, on the evidence available, rejected. Now, notwithstanding these uncertainties, it is important to note that Mr. Justice Warren stated that it was clear to him that, and I quote, the whole basis of the strategy adopted by the defendant was to ensure that the claimant would lose its claims to, again I quote, accrued rights in a situation where some of those rights were clear. Now, the value of these lost rights does not emerge from the judgment with any clarity, but it does seem reasonable to proceed on the basis that the defendant did breach the terms of the original contract with the claimant, and the strategy that it adopted was designed to eliminate any liability in respect of these breaches. In this context, it's been argued by Iona Branford and Jodie Gardner that these findings should have been sufficient to make out a case of economic duress on the basis that the lawful threats made by the defendant were, in their words, directly related to the defendant's previous unlawful conduct in the form of their breach or breaches of contract, and so should constitute the application of illegitimate pressure. This claim, they say, is rooted in the principle that a contracting party should not be allowed to escape the consequences of their prior unlawful conduct. This view was not, however, one shared by the Supreme Court, at least the majority, who seemed to focus on the lawful pressure applied by the defendant without attaching any significant weight to the factors which led to that pressure being applied. This compartmentalisation is most apparent in the judgment of Lord Hodge, who, in the critical 2 paragraphs in which the law is applied to the facts of the case, made passing reference to the fact that the defendant was demanding of a waiver of a claim that it was in breach of contract, but otherwise he focused on the lawful conduct of the defendant in reducing the claimant's ticket allocation and the take it or leave it option which the defendant gave to the claimant. But this, in my judgment, is to view a subset of the defendant's actions divorced from the strategy which it had adopted to eliminate its potential liability to pay the commission that was due under its contract with the claimant. While the threats which directly induced the contract were lawful, they were nevertheless a central part of the defendant's strategy to avoid any liability in respect of its breach or breaches of contract, and these breaches should not be swept aside as if they were causally irrelevant. On the other hand, it can be argued that the fact that the defendant was in breach of contract in failing to pay commission to the claimant should not of itself suffice to lead to the conclusion that the pressure applied by the defendant was illegitimate. It was perhaps for this reason that Lord Burrows insisted that there must be a bad faith demand, but the critical factor which persuaded him to conclude that lawful act duress was not established was that on the facts as found by Mr. Justice Warren, the claimant had not established that the defendant did not genuinely believe that it was not entitled to withhold the commission claimed by the claimant. Thus, in his view, the past breaches by the defendant were not enough of themselves to turn the case into one of lawful act economic duress. It was necessary to go further and prove that the defendant genuinely believed that it was not entitled to withhold the unpaid commission. And of course, this was not the approach adopted by the majority. For them, a bad faith demand did not, without more, lead to a finding of lawful act economic duress, because the doctrine of lawful act economic duress is more limited in the context of commercial relations. In their judgment, it was necessary to go further and establish that the defendant had behaved in a highly reprehensible way, and that the claimant couldn't do. While there are clearly uncertainties about the scope of the doctrine of lawful act duress that was recognised, at least by the majority of the Supreme Court, does the decision have the likely consequence that English law will lose what Lord Burrows referred to as its long-standing reputation for certainty and clarity? I would suggest it does not. As Lord Burrows observed, lawful act duress is controversial, and it is an issue on which reasonable minds can differ, and where certainty is accordingly more difficult to establish. Had the only concern of the Supreme Court been to lay down a clear and predictable rule, that would, in my submission, best have been done by shutting the door entirely on the recognition of lawful act duress. It would have been a clear and simple rule. But had it done so, it would have left the door open to powerful contracting parties to devise strategies that involved the use of lawful threats to persuade a weaker party to waive its valuable contractual rights without fear of judicial oversight. In this context, I think there is a legitimate interest in upholding standards of conduct in the negotiation and renegotiation of a contract, and that the fact that the stance adopted by the defendant is technically lawful should not render it immune from scrutiny by the courts. In other words, the interest in certainty has to be balanced against the legitimate interest of the law in laying down minimal standards with which parties are expected to adhere in a contractual context. Thus, to make the point that I've already made, what the Supreme Court wished to avoid was not uncertainty per se, but unwanted or unacceptable uncertainty. And while there's some force in the submission that the majority of the Supreme Court could have done more to lay down a clear rule that would establish the limits of lawful act duress, it's unlikely to impair the reputation of English law for certainty and clarity, particularly when account is taken of the limited scope of the doctrine that has been recognised and the legitimate concern of the courts to ensure that highly reprehensible conduct is not encouraged and indeed is discouraged. I make two final points by way of conclusion, and both relate to aspects of the decision in Times Travel. The first is that Lord Hodge affirmed that English law has never recognised a general principle of good faith in contracting, although it has developed piecemeal solutions in response to demonstrated problems of unfairness. One of the objections to the recognition of such a general principle is the uncertainty that it would likely generate, and that uncertainty may be a price that's not worth paying. That said, it seems unlikely that the debate over the role of good faith in English contract law will go away. Insofar as contracting parties choose to draft their contracts making express use of the language of good faith in the performance of their contract, effect will be given by the courts to these terms, albeit there is a level of uncertainty as to what good faith means in any particular contractual context. More difficult, perhaps, is the implication of a term requiring the parties to act in good faith, but such an implication seems unlikely in the context of a commercial contract negotiated at arm's length, and even if such a term were to be implied, its demands may not be extensive. The stance of English law on this issue may seem open to question when seen in the context of the many legal systems in the world where good faith is a core contractual doctrine out of which the parties cannot contract. But it's one thing to work with a doctrine that's well established and well understood in a particular legal system, as for example in the Netherlands. It's another to introduce it as a latecomer into a well-established legal system where its introduction has the potential to generate uncertainty as to the continued validity of recognised rules of English contract law. The caution of the judiciary in relation to any possible recognition of a general principle of good faith in contracting is understandable, given the preference of the common law for incremental rather than radical developments, in particular when account is taken of the uncertainty which such radical changes as a good faith general principle might bring about. My final point concerns the statement by Lord Hodge in Times Travel that English law recognised no doctrine of inequality of bargaining power. And this is perhaps a fitting point in which to conclude this Denning lecture, given that it was Lord Denning himself who is most closely associated with the claim that English law recognises such a general principle or doctrine. I refer here, of course, to his judgment in Lloyd's Bank and Bundy, where he famously stated that English law gives relief to one who, without independent advice, enters into a contract upon terms which are very unfair, or transfers property for a consideration which is grossly inadequate, when his bargaining power is grievously impaired by reason of his own needs or desires, or by his own ignorance or infirmity, coupled with undue influences or pressures brought to bear on him by or for the benefit of the other. It would, I think, be fair to say that Lord Denning's general principle has not been well received either by the House of Lords or by the Supreme Court. But it may be that some of the criticisms miss the mark. When careful account is taken of the various components which Lord Denning identified, substantive unfairness, lack of independent advice or weakness in advantage taking, it can be seen that this is no easy test to satisfy. Further, sight should not be lost of the fact that what Lord Denning was seeking to do was to identify the general principle or the single thread which united pockets of case law which had hitherto each been seen as a separate category. The stance which English law has chosen to take is to reject the general principle, but as Times Travel itself demonstrates, to continue to recognise a range of individual instances where exceptionally English law has chosen to intervene to set aside unconscionable or extortionate bargains. And the continued existence of these disparate jurisdictions is not conducive to the cause of certainty. But that's not their function. Their function is to protect the vulnerable from exploitation. And that takes us back to the point on which we started, namely that the pursuit of certainty is not the only or even the ultimate aim of the English law of contract, and its importance does depend on the context in which the contract was concluded, the identity of the parties to the contract, and the quality of their behaviour. The promotion of certainty can be seen at its strongest in RTI and MUR, where the issue was one that concerned the interpretation of a commercial contract concluded between a Dutch company and a Jersey company who had chosen English law as the law to govern their contract, the very type of transaction that Lord Hamblin had in mind in the quote at the outset of this lecture. In Waller-Edwards, its role was more nuanced. being directed towards providing clarity to the commercial party to the transaction, while seeking at the same time, or the Supreme Court seeking at the same time, to provide an appropriate level of protection for the vulnerable party to the transaction. Finally, in times travel, the aim of the Supreme Court was not to avoid uncertainty per se, but rather to avoid unnecessary or unwanted uncertainty by creating an exceptional jurisdiction to set aside a contract where the more powerful party has acted lawfully in making the threats which it made, but has nevertheless behaved in a highly reprehensible manner, which can be described as the application of illegitimate pressure. The importance attached to certainty in English law is greater than that to be found in many other legal systems in the world, and may at times be greater than some of us would consider to be desirable. But it's not absolute, and as the cases discussed in this lecture demonstrate, the Supreme Court's pursuit of legal certainty is moderated by a desire to ensure that a minimum level is protected to vulnerable parties, and by a willingness exceptionally to find the existence of lawful act economic duress in the context of a commercial negotiation where the pressure has been applied in a highly reprehensible way. The balance thus struck, while not appealing to everyone in every respect, appears to me a reasonable one for the courts to strike, and in my judgment it will not place in jeopardy the reputation of English law for the promotion of certainty and predictability. Thank you very much.
Many thanks, Professor McKendrick. I'm going to see if there's any questions first. I didn't see any come up on the iPad, but I just wanted to, yep, I see a couple of hands. I have to take my glasses off to see. Okay, I think at the back first, and then we'll come to you.
Thank you very much for a very interesting expose. RTI and NUR.
Yeah.
I'm very puzzled because one of the critical issues in delivery of contracts, essentially fungible contracts, is that I deliver something that you can essentially has value relative to something else, so euro relative to the dollar. Yeah. Usually people reject delivery of, for example, currency as opposed to a commodity. That seems to be much, because I need physically the commodity isn't completely fungible, but a dollar and a euro, very fungible. And my question is, for economic business effectiveness, I can see many ways in which, for example, I could have delivered a deep in the money option that exchanges euros into dollars, which is essentially 99.9999% dollars. Would that have made any difference? And what is this fascination with, are we really going to count, notes with their little numbers on them? Or at what point is fungibility, That's my question.
Yeah, I'm not sure that I know the answer to it. I mean, as I read the decision, and this is where I'm glad I'm an academic sitting on the side rather than the judge having to make decisions, is that it seemed to me that one of the concerns that was animating them was that once you open the door, how then do you close it? And so I think, in their view, it would actually turn on whether or not you got US dollars as set out in the terms of the contract. Now, again, I mean, one of the elements that seems to me to be common to both times travel and RTI is that the Supreme Court is at some distance from the fact-finding process for pretty obvious reasons. And they've got to work with the facts as they are. And that's why, in a sense, I started with that first point, not as a criticism of the Supreme Court as such, but that what you don't really have is an analysis of what actually did amount to contractual performance under the terms of the contract, because the case appears before the Supreme Court, it being accepted that what is being tendered is non-contractual performance. And similarly, I think in Times Travel, again, in fairness to Mr. Justice Warren, he didn't know what the law in relation to lawful act economic duress was. I think had he known, let's say Lord Burrows had been right, but what you needed was a bad faith demand. At trial, you would expect the focus to be on that particular issue. But it does seem to me at times, and we have a Supreme Court Justice here who can speak to this in a way that I could never ever do. It does seem to me that there are times when you just have to accept the findings of fact that have been made. And so I think your point goes to the prior question of whether or not this is contractual performance.
Thank you for that very thought-provoking lecture. I think we're talking about two things here, are we not? One is, can we have rules of law which are clear? I think we can, and that's something that my colleagues and I tried very hard to do when I was a Member of Parliament and we were passing legislation, although we were not always successful. The other question is, can we have certainty in the outcome of the application by a court of particular facts to those clear rules of law? For my part, I think that is impossible, because the facts which will be laid before the court in cases are infinitely variable. So I think the best we can hope to do, whether we are legislators or judges, is to set out clear rules and then hope that the application of those rules will result in a just and fair result.
Thank you. I partly agree, partly disagree. I think that when we are trying to formulate clear rules, one of the things we need to try to think about is how they might apply in what you call the standard case, so that you do want a degree of predictability in the application of the law to the facts of a particular case. But I do accept there are certain areas where that is much more difficult to attain. There is actually a fourth section of this paper, which for reasons of time I knew I was never going to get into, which is about the interpretation of contracts, which does seem to me to raise exactly the point that you are referring to, that what I think you can see is actually a high degree of stability in the framework which the Supreme Court has developed for the approach to interpretation of contracts, but the application of these principles to the facts of the case can be extremely difficult because of the infinite variety of factual situations that come up, or because the parties have made provision for something that approximates to what happened, but not exactly so. And in a way, RTI and MUR shows that in some respect, in that at every level, you've got different views being taken as to how you apply the law to the facts of this case and what reasonable endeavour is actually required on the facts.
Thank you for a characteristically incisive presentation. I've got a comment on and a question on good faith, and also a question on the certainty. I was once asked, giving a talk in Germany, why English law, in contrast to German law, had no general principle of good faith. And I said, well, Section 242 of the BACFI, the German Civil Code, has a 4-line rule embodying the principle of good faith. followed in the main analysis by Staudinger by 500 pages of small print analysis.
Yeah.
That, I said, is why we do not have the principle of good faith in English law.
Yeah.
Now, coming to, so I'd like to ask you whether you actually do yourself favour the adoption of a general principle of good faith. And secondly, on certainty, I've often thought myself that there's nothing like a healthy dose of uncertainty for promoting a reasonable settlement. Do you agree?
On the second point, I can see the point that you are driving at, but it doesn't seem to me it's an entirely desirable position to be in, that because you cannot predict the outcome of litigation with any confidence, you're then driven to settlement and to giving up your rights. It does seem to me to be important as citizens that we know what our rights are and can give effect to them, and I think that's true of commercial parties as well. On good faith, I have to say I kind of change my view from day to day, which is not the most helpful of stances. If we had a civil code, I would support good faith in the sense that I think what good faith can do, particularly in the kind of German and Dutch context, is it allows the law to adapt when you can't change the code. Whereas the common law system seems to me to have that flexibility that's built into it already. And the risk is, and this is what I meant by the latecomer, once you introduce good faith principle into English law, is it then just a recipe to litigate points that have previously been established by authorities? So, for example, I mean, it's clear law that you can accept. You can terminate a contract for a reason that you didn't know at the time at which you exercised that. You can terminate for a bad reason. Now, if you were going to have a good faith doctrine, does it change that? We know there's no duty of disclosure. Does it change that? So where I am more focused is on the point that if the parties expressly use the language of good faith, that is a term of the contract that should be given effect. And I think English law has now got to that point. Implication of a term in good faith, I mean, if it's necessary to make the contract work, I'm a little bit concerned about Lord Justice or Lord Legate's relational contracting material, because I think it gives rise to the risk that counsel then tries to argue this is a relational contract for the very purpose of bringing in a good faith term. And it seems to me that the McNeill literature on relational contract, which is significant, seems to me to be talking about a relationship that is open textured. I mean, when I'm teaching students, I always give the example of marriage. You know, that it's not kind of defined terms, it's an understanding between the parties that you will act in good faith. And the reason that's important seems to me that a commercial joint venture is not the same thing as a marriage. You can have one that's expressed flexibly where good faith is appropriate, but you can have others which are being lawyered to death, where the parties are standing on their rights. And even if they use the language of good faith, it seems to me they're using the language of good faith in particular contractual clauses. It's not a general principle. So that if you have 37 references to good faith in a contract, what have you got? You've got 37 examples of good faith. You don't have a general underlying principle. So, I think I can see the kind of Legate Yam Seng view that you can introduce good faith with kind of English characteristics, if you like. You can bring it in an incremental way. But once it's out, what use are counsel going to make of it, and to what extent will it actually generate uncertainty by reopening issues that we previously thought was settled? Sorry, that was a rather long answer, but...
Okay, thank you. I don't see any more questions in the audience or any online. So, and my alarm rather unhelpfully went off. I do apologise. I was trying to keep time well, but it went horribly wrong. So once again, thank you so much for giving up your time to come and speak to us. We do have a small token of appreciation for you. So thank you so much.
Thank you very much.
Much appreciated. So before, I know I'm standing between you and the canapes and the drinks, but before I do, I just wanted to take another few minutes. So as many of you will probably know, to celebrate our 55th year, 2020, we developed and introduced the BACFI Fellowship Award. This year, our 60th year, we had 2 nominations that we felt were both equally worthy of the award. I wanted to thank Ian Brooks-Howells and Ros Wright for being part of the judging panel, but unfortunately neither of them can be here tonight. Christiane Valenceau, so she served on the BACFI committee for many, many years, including 3 years as chair from 2007 to 2010. During her time on the committee, she really worked tirelessly for BACFI, and she very much helped BACFI become recognised widely across the bar, including a lot of work on the Bar Council and the BSB on pupilages and the 3-year rule, which still rumbles on. Christiane also led work on the new practitioners programme and devised an ethics module for Middle Temple, which was adopted then by all 3 of the inns. Her thoughtful and knowledgeable BACFI policy papers helped ensure that BACFI got greater recognition amongst the bar generally and at the Bar Council, and she's really led the members' interest in the forefront of this work and campaigned tirelessly for change and greater recognition for the employed bar. So one of the awards goes to Christiane. Stephen Collier was a member of the BACFI committee and treasurer of the Bar Council from 2011 to 2014, during which time he initiated a restructuring of the Bar Council's income base, including a reset of the practising certificate fees. Stephen's work helped put BACFI on the map with the Bar Council and secured status as a specialist bar association. His ability to facilitate debate between the self-employed bar and the industry culminated in organising a roundtable conference at Grays to promote shared pupilages. Stephen invited several leading chambers heads and general counsel from major industrial firms, including his own employer, to that event, and he himself has trained numerous pupils in his time at a leading healthcare company. A review of his company's experience was submitted to the Bar Council, first-hand evidence of the quality of the non-financial services in-house pupillage. So please congratulate me in, please join me in congratulating, sorry, it's been a long day, both of these worthy recipients of this year's BACFI Fellowship Award. I know Christiane can't be here tonight, but we'll get that award to her. But Stephen, maybe a round of applause and come up and get your award. Thank you.
Very much.
Congratulations.
Sorry, there is one additional agenda item. As Gaynor has acknowledged, this evening or later this month marks the end of her 4-year term as chair of BACFI. And I just wanted to take this opportunity on behalf of everyone at BACFI really to express our deepest gratitude for Gaynor, to Gaynor for everything she's achieved over that period. Gaynor's been a phenomenal ambassador for the employed bar, really at every level, whether at events such as the Denning, down to student panels, all numerous types of activity. She's also demonstrated real clarity of leadership and strength of leadership in what can candidly sometimes be like herding cats. But above all else, Gaynor is just a wonderful person and a real delight to work with. So Gaynor, a little something to say thank you.
much. I really appreciate that, everyone that's been involved in that. And like I said, it's been such a pleasure to be the chair, and I'm not going anywhere. I'm just not going to be chair. So I'll still be here, still be annoying everyone, I'm sure. But yeah, thank you. And now please do go and enjoy the canapes and the drinks. And it's lovely to see everyone. Thank you.